Good morning, Ms. Losnov.
Good morning. Good morning, Chief Justice, Associate Justices. May it please the Court, my name is Elena Rosnov, and I'm here on behalf of John Thissell. Your Honor, the one issue that I bring to the Court's attention this morning is whether or not Mr. Thissell's due process rights were violated when, during his probation revocation hearing, when the Chief Probation Officer entered records, GPS records, into evidence.
Is it your position that the right to confrontation applies in probation surrender hearing?
It is my position that there is some right to confrontation that is, and Durling admittedly says that there is a right to confrontation in probation surrender hearings. I'm sorry.
What case says that?
The Durling case in Morrissey and Gagnon, Morrissey and Brewer, and Gagnon versus Scarpelli, they all say that probation revocation hearings the probationer is afforded minimal due process rights, and I understand that due process is a flexible issue, but one of those rights is the right to cross-examine adverse witnesses. And I believe that Justice Cowan also wrote in her decision in Commonwealth versus Wilcox that minimum due process right is afforded to probationers.
But let me ask you this.
Yes.
Does this end this case? Number one, Crawford is inapplicable at probation revocation hearings, at least so as far as we know, till it's changed. And the documents in question are hearsay. Hearsay is permissible, but they're reliable hearsay.
If they're reliable.
I mean, they appear to be reliable, so does that end the case?
I don't believe so, and our position is, in fact, that these documents are not reliable.
Then why aren't they reliable?
Our position is that they are not reliable because they're not, we don't know where they came from or who kept these records. There was an issue at the lower court, and the testimony of the probation officer was that these were the records kept by the Department of Probation. And I'm saying, well, that's not necessarily true. The chief probation officer testifies that this gentleman is wearing a GPS bracelet. That signal gets transmitted someplace in Boston at the Elmo Processing Center. And at the Elmo Center, they can print out, as they did in this case, the information saying that the individual wearing the GPS bracelet was in a place that he shouldn't have been, or in this case that he also made statements that he was someplace that he shouldn't have been. But he doesn't know anything else about them. He doesn't know how the records are kept. He doesn't know where they're kept, how often, the logs are checked and printed. And his testimony, admittedly, he says, I'm not an expert in this. And admittedly, he doesn't have to be an expert. He doesn't have to have personal knowledge pursuant to Commonwealth versus Reed. But I think that in a case where these records are not attested to or sworn to or certified, and there's nobody at the probation
Don't the records speak for themselves? The records include maps, right?
They include maps.
And they indicate where the no-access zones are.
They have a radius, yet they have a circumference.
And didn't they reflect that the defendant's GPS indicated that he intruded into those exclusion zones?
Yes, that's what they appear to say. However, and in my record, and I didn't cite this specifically in the brief, but in the record appendix to my brief on pages 27 and 28, we appear to have two pages, page 10 of page 10. One of them has entries on them. Page 27 has an additional entry on it. I'm sorry, page 28 has an additional entry on it that page 27 doesn't have. So which one is page 10 of page 10? Is it the one that says that they faxed the alert to the court twice on September 14th, 2007? Or is it the one where they only made one fax? I mean, it's just both of these documents were entered at the probation violation hearing.
Do we know what the percentage of error is in the GPS monitoring system?
We don't know that, and that wasn't challenged during the lower court proceeding. However, I can tell you from experience in the district court that we have several instances every day where these bracelets are going off, they're losing signal, and these people are found by the police to be in a place that they're perfectly permitted to be.
So you're not really questioning GPS technology. We all have come to rely on GPS technology to tell us where we are.
Yes.
You're questioning, I think. you're questioning something else, not just the underlying technology, but these records specifically.
Exactly. It's not, and the challenge to this, it wasn't the scientific challenge to the GPS. It was, if we're going to use these records to incarcerate an individual, in this case he was incarcerated for an additional 2.5 years, that these records have to be reliable. They have to be something more than, oh, he was in this place, so let's violate his probation because he shouldn't have been here.
Well, don't they say more than he was in this place? They tell us what time. There's a log, time log, too,
There's a log, but I'm not exactly sure. And if you read this first page here, and this is in my record appendage, page 16, it says offender history. It says that you pull this drop-down menu and you can put in certain dates and times of what you want. These aren't logs, in other words, that are printed out and kept daily that are specifically tracking Mr. Thissell. These are only made at the time that there's alleged to be a problem, that they're dropping down, they're hitting a print screen, and then they fax it over to probation, and probation holds them as true. They're saying, you know, at the probation revocation stage, here are these documents. Please take what they're saying as the truth, even though I really don't know how they collect this data.
Okay, so what do you say would be the minimum that would be required of a prosecutor seeking to obtain a probation violation based on a breach of a 2,000-foot restriction?
I would say that at a minimum, something that says that something that's signed or certified or attested to that says that these records are kept in a certain way, and they are saying what they purport to be saying.
So you want the equivalent of a keeper of the records?
Correct. And I don't think that that's particularly an invasive thing to ask. I know that Durling said that in that case there was good cause to dispense with the confrontation because the officers would have to leave their areas and they would put the citizens of that area in jeopardy without their officers. But we don't know that to be true at the Alamo Processing Center. Is there one person that sits behind the computer and waits for the signals to come off?
So if the legislature passes a statute that says the records at the GPS monitoring system can be admitted at a probation revocation hearing if they are certified by the keeper of the records, you're okay with that?
I think it would put more meat into it, yes. It's something more than just this computer printout that in the record I have here that shows you that it's saying two different things. I think if it says something more, at least gives somebody accountable. It puts somebody to be more accountable if there are questions about what happened, if the signal was wrong, what happens if he's in the right place that he was supposed to be, what happens in those situations. We don't have anybody here.
Ms. Losnoff, was
Yes.
there any evidence introduced by your client that on September the 14th at 9:41 he was, I'm looking at page, record appendix page 28,
Yes.
that this shows he entered the Herrick exclusion zone, that he was in fact, someplace else?
No, he says, I believe that the evidence that was presented was that he drove through it on his way to the Shaw's supermarket. This area in Beverly, as I understand it, and if I'm understanding your question right, this area in Beverly, it's a huge area. And from the way that I understand this is that the center point of this exclusion zone, of this imaginary line, is the address that he's supposed to stay away from. Now, he's driving through, it seems to me, the edge of the exclusion zone on his way to Shaw's supermarket. The entry and the exit is about 55 seconds long, I think, in this case. Not even.
But isn't the circumference of that, so he doesn't deny that he was there. He just says, isn't his sort of defense, how was I supposed to tell it was within 2,000 feet of the, but even without the GPS,
Yes.
I mean, let's just say, for example, you had a police officer who saw him driving exactly where he was. He would have the same defense. I mean, the problem, it seems to me the problem isn't the GPS. The problem is you're saying that the underlying order that says stay 2,000 feet away from Beverly Hospital, I think that was this part of it, is impossible because how is a person supposed to know what 2,000 feet is? I mean, isn't that really what you're saying? Which has nothing to do with the GPS.
In part, yes, that is what I'm saying.
Was he ever given a picture of a schematic of the zone that he was supposed to stay out of?
No. In fact, it's testimony during the probation revocation hearing that he's just told, stay 2,000 feet away from this address and this address.
One question. There are, on September 14th, there were 2 or 3 zone violations.
Yes.
One of them, didn't he drive by her house, or am I just wrong about
No,
that?
his mother lives, I guess, my understanding is his mother lives down the street or down past where the wife's, his former residence was. So at the time that they picked him up on that day, he was at his mother's house.
And how many feet away from his?
That I don't know. I believe it's more than 2,000 feet, but I'm not sure. According to my client, when
my question is, did he drive by the house he's supposed to stay away
I think he drove down the other end of the street, I believe.
Isn't when an order to this effect is put, isn't it an obligation of the defendant to say, Your Honor, my mother, who is unable to drive a car, and I can only visit her, the only way I can see her is to go to her house, is down at the end of the street, and there's no way for me to get there other than driving right past my wife or former wife or whoever the alleged victim is?
I believe he could have said that, and I caution as I say this, but there have been times where he was at his mother's house. He told me 6, 7, 8, 9, 10 times and never received a phone call saying that he went into the exclusion zone and never thought it was a problem previous.
Why isn't it incumbent upon a defendant who is the recipient of this kind of an order, stay 2,000 feet away from a particular location? Why isn't it incumbent upon him to go get a map and draw a circle around the area to stay?
And doesn't he have regular reporting with his probation officer?
I believe that he did have
Yeah, so
reporting.
you say to your probation officer, Mr. or Ms. Probation Officer, help me out on this. I want to comply with this. You know, I've drawn the circle roughly. Now you see there's a problem with my mother's house, and also, by the way, that's the closest pharmacy, and I might have to go there. So how do I deal with this? And the probation officer, says, well, let's check with GPS, and we'll get, it's not as if.
I think that if the relationship were able to be that way, that it would be easier. But again, the only time that this became an issue was this day. They sort of, and I remember the appeals court justice saying that they applied sort of a tourniquet approach. So he had been doing these things all along, going to his mother's house, and then all of a sudden they had just sort of had it, and they said, that's it, we're going to violate you. But he'd been doing it all along.
And wasn't there a finding by the court of a violation for his submerging of the GPS?
There was a violation. Well, the violation was the notice was given, but ultimately the trial judge didn't rely on that when he was making his ultimate finding. He made the ultimate finding on the exclusion zone entry and exit, if I'm reading the record correctly, and said that he would take in the testimony about his submerging the bracelet as his state of mind at the time that he did it, whatever that was supposed to mean. And if there are no further questions, I will rest on my brief.
Thank you, Ms. Losnoff.
Thank you very much.
Mr. DeLosa.
Good morning, Your Honors. May it please the Court, Ron DeRosa on behalf of the Commonwealth in this case. And Justice Gantz, if I could just correct my sister, I read the record differently than her. According to the judge's findings in violation, he simply stated that he found the violation based on GPS violations on diverse dates. So I think that the submerging of the bracelet was included along with the exclusion zone violations in the finding the defendant in violation of probation.
So it was simply his manner of speaking to the probation officer that was not a basis for the violation?
No, that he had said that he considered that as in regards to the defendant's state of mind, but not for a violation of probation.
So you're saying that regardless of what happens with regard to the GPS issue, is a violation based on the submerging of the GPS?
Submerging, and also in regards to the exclusion zones as well. Those three, there's certainly a basis in the record for the defendant's finding in violation based on those three violations.
Mr. DeLosa, do you agree with the conclusion of the appeals court that these are are not hearsay?
I do, and I make that argument in my brief. It's not my strongest argument, Your Honor.
Is it a pretty weak
Say
argument?
not.
It is a weak argument.
But that seems to be where the appeals court starts out.
Yes, Your Honor, because I think they went through the analytical framework of starting out as determining it wasn't hearsay, then that it was a business record, and that it was essentially reliable. Because under Durling, the first step the court is to take is to examine standard evidentiary rules and determine if they meet the standard evidentiary rules, they are therefore presumptively reliable. If not, the court can then go on and look at the substantial reliability and trustworthiness of the documents in making that analysis. So that argument, in essence, is that the GPS device is a tool making a measurement.
It seems to me that this is quite different than somebody getting out with a tape measure. The buildings don't move. If you're in 1,000 feet of a school, the school is there. 1,000 feet is 1,000 feet. But to say that you were there on a particular day, seems a little strange.
No, the real difference between this and the case that the court relies on is that in that case there was a witness saying here's what I say. This is
what I
1,000
measured.
feet. We don't have a witness here. We just have the paper.
But I would suggest the maps in this case may actually be almost, in a sense, a better evidence than the officer.
It's not a
You
map.
can't cross-examine the piece of paper.
No,
It's not a map. You can say, here's a map of Boston. I don't know whether that's hearsay or not hearsay, but if you say, and on this day you were in this place on Boston, that's very different. That's not a map of Boston. That's showing you were here.
Based on a technological device, Your Honor, yes.
But the fact that it's technological doesn't make it
Non-hearsay.
non-hearsay.
I understand, Your Honor, but they were also, based on my argument, admissible as business records as well.
Well, that's a different issue.
My argument that, based on the appeals court's decision that it was not hearsay, is certainly a weak one, and I make the both. But I went through the analytical framework. First, that it's not hearsay, but second, that it's also admissible as a business
So
record.
how about, so the probation officer keeps records. All probation records are business records?
According to the language this court has used in the past under Furtado and Savageau, Your Honor,
So the
records.
probation officer can write anything down, anything, and put it, report, saw defendant on within 1,000 feet, put it into my probation officer file. That becomes a business record?
Well, Your Honor, I think so, because that it's based on the probation department's duty to supervise. All that a business record is required is that it was made in good faith in the regular course of business and before. Well, in that case, Your Honor, where if he had written down that he had seen them within 2,000 feet of the house, I think the argument in that case is that it was made in anticipation of a surrender hearing.
No. Every Friday I make it a habit to follow my probationers around.
And I do see there, but I would suggest they were made in good faith in the ordinary. If they were made in good faith in the ordinary course of business, but not in anticipation of the litigation, then yes, they would qualify as a business record. As the
Is there any reason why we're keeping track of these people other than to make sure?
well, to make sure that they're complying with the terms
So
of
that
probation.
if they violate it, they can be brought in and have their probation revoked.
It only happens in the event that there's the records, and that
But
brings.
that's why you're keeping it.
I-
Otherwise, you just say, please hold up your hand and promise that you'll never be within 1,000 feet. And somehow we don't sort of accept that as a foolproof method, so we put a bracelet on somebody, and the purpose is to watch. So as soon as they go outside the area, we bring them in. That's the purpose, isn't it?
Well, but in that event, Your Honor, the whole purpose of GPS is actually for the benefit of the defendant and the probationer in order to allow him to keep his liberty so that probation can keep track of him.
Doesn't turn it into a business record.
Well,
That's a different issue.
In any event, Your Honor, all that's required under Durling in a probation revocation is that they're substantially trustworthy.
If the charge for violation of probation was that the defendant was driving while drunk, could the little piece of tape, ticker tape that comes out of the alcohol meter that he blows into, could that be admitted into evidence in this case, in a case for violation of probation, without the officer testifying?
I would suggest that that's not how I believe the breathalyzer test the records are kept anymore. I believe they're printed with other documents. But singularly, that piece of paper that showed that he blew over the limit, ostensibly the condition in that case would be to show that he had consumed some alcohol, and not that the condition of probation wasn't that he, in the event that he drove drunk. It would depend on the circumstances of the case, Your Honor, whether there were other documents that showed the machine was maintained properly, and that the reading on that little ticket was reliable. So based on that, it could be considered with the other documents that showed that
Do we have any
maintained.
sense of how many people are on GPS systems in the Commonwealth at any given time?
I don't.
It was in the paper this morning.
I-
It's 1019 or something like that.
I understand. I read the article quickly. I was made aware that there was an article this morning. But
And if it's
I'm
in the
not-
newspaper, it must be correct.
based on a study. And again, no, there's no sense in this record as to how many people are in the Commonwealth are on GPS monitoring.
But it's a fair number.
Yes, it would be a fair number, and certainly now that the legislature has mandated it with sexual offenders, that number certainly probably will keep increasing as time goes on.
Now, I'm a bit confused. You're not contending that if this were a trial, these would be admissible based on the probation officer's testimony as a business record?
That's what I contend in my brief, and I understand that may also be a weak argument that these would be admissible at trial, but certainly at a probation revocation hearing.
Okay, so I'm a bit confused. Are you saying that if this were a trial, these would be admissible based on the probation officer's testimony as a business record, or are you saying, okay, they're not admissible as a business record based on this evidence, but they're reliable hearsay anyway, and that's all that's required for a probation hearing?
Yes, Your Honor. That's
the latter.
That's the last one that I'm contending.
That's your first.
I understand. I understand that's the strongest argument.
Notwithstanding that you managed to persuade a very distinguished judge in the appeals court that you had two other powerful arguments.
And also, I believe there's also an unpublished decision from the appeals court, Commonwealth versus Kushner, that also saw them as business records and as substantially trustworthy and reliable, that I did cite.
And you don't think, I take it it's because it's a probation hearing, assume for the minute that they are business records. The problem of just having them faxed from the Elmo Center to the probation officer in Essex and then just admitted without any certification doesn't matter.
Not for the purposes of the probation revocation hearing, Your Honor. And I think, given the purposes of probation and the language in Durling, the spirit of Durling, that, where it specifically pointed to the heavy travel burden of making police officers truck around
all you
the
have to do
state.
is fax the certification as well.
I understand that, but certainly, as Justice Ireland said, the records speak for themselves. They can.
So how do we explain 2 pages 10? My quick review is they're not entirely different, but I mean, you've got 2 pages 10, same date, same printout, slightly altered.
I'm sorry, Your Honor.
The 2 pages 10, which are in the blue brief at about 28, I think. They are somewhere around about pages, 28.
27 and 28.
27 and 28. They, the same date, same time, trackmate, but they're a little different.
It appears that there's one entry that's different, that's made about an hour and 10 minutes after the last one on the page. It's not very. The rest of the document isn't different. I would suggest it simply shows one more entry, and was printed out from. And again, there's no evidence as to how these were
Page
printed
10
out.
is a work in progress, I take it. And depending on what time of day you print it, it'll have different
is.
information.
It's a constant monitoring of, and
Yeah.
constant entries are made. And depending on, as Your Honor said, depending on when you print the document out, another entry could have been made if it's 5 minutes later. If he simply goes home and another entry is made on the logs that show that he entered his home during that time.
Now, it seems to me, I mean, I don't really know this, but there's a sailor or solar load.
So here, Your Honor, I believe.
So, yeah, what load?
That-
And it seems to me that you really cannot get from point A on Helix Street to point B on Thissell Road unless you touch on that, and if that's essential for you to be there.
I believe that's the Beverly Hospital exclusion zone violation, Your Honor.
Oh, I understand that. I'm just saying if for some reason you had to be there, there's no other way to get there. Generally speaking, if you wanted to get, for example, to Helix Street Extension, there's a long way around you can go, but you can get there, but you actually cannot get to that piece of Solier Road. So,
And you know, Your Honor, I believe one of the justices asked the question as to what evidence the defendant put on. The defendant didn't put on any evidence in this case. It was made through argument of counsel that he was traveling in a very heavily traveled area, in sort of mitigation of the fact that there were these violations that occurred.
If the defendant wanted to challenge the GPS records, is there somebody, do we know if there, as a matter of record, if there is somebody he could have subpoenaed into court to cross-examine?
We know he could have summoned in staff from the Elmo Center as to how they're kept and possibly the process, but as to the technology, it would have to be, I would imagine, some sort of scientist with specific knowledge as to GPS technology in order to challenge that he wasn't at these particular places at specific times, which wasn't done in this case. He in fact admitted that he was in these places, but they were minor violations. So I could imagine, in regards to how the records are kept, it would be someone from the Elmo Center, and in regards to the technology, it would have to be some sort of scientific expert in order to challenge the science of the GPS technology.
do you happen to know whether probation has a policy that as soon as you blip once that you get pulled in for probation revocation?
I don't know if they have. There's no evidence of that in the record, and I've practiced in district courts. I don't know, but I think you can infer not, Your Honor, because there are actually other violations seen just in these records before the court where the probation department didn't move to violate the defendant.
Might it be an unreasonable inference to suggest that one reason why they hauled him in was because he was rude to the person at the other end of the phone when they called him in?
It may have played into it, Your Honor, but it also may have played into the fact that
Wasn't it that the submerging?
and he had submerged the bracelet and caused them to lose contact with him, which obviously is a serious violation when you're on GPS. Also, this was a domestic incident where one of the violations is he drives by the marital home. Certainly those would be serious violations. And also, given the defendant's history, he had been on probation for, I think, 3 years at this point. There have been numerous violations that were on the record. So as the probation officer stated in the record, at this point he felt that he wasn't a good candidate for probation. In closing, I would just state that I would suggest that the records were sufficiently reliable and trustworthy under Durling. And if this court has no further questions, I would rest on my brief.
Thank you, Mr. DeLuisa.
Let's keep going.